Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 misconceptions about the settlement communications rule. What is that? I'm talking about the rule that says generally communications about a settlement or a compromise of a disputed claim in a lawsuit are not admissible in court. So, for example, if you have a lawsuit in federal court, Rule 408 of the Federal Rules of Evidence generally says that compromise settlement negotiation statements are not admissible. Most states have some version of Rule 408. In Texas, where I practice, we have a similar rule in the Texas Rules of Evidence. Let me give you an example of how that rule typically operates. Suppose you have an ordinary car accident case. There's a lawsuit and there's a negotiation of a settlement, and the defendant in the case during the settlement negotiation makes the statement, "Yeah, I admit it, I ran the red light." If that's a disputed issue in the lawsuit, then that statement, "Yeah, I ran the red light," is usually not going to be admissible under this rule. But a lot of people, even lawyers, have a lot of misconceptions about how this rule operates. Let's get into those. The number 5 misconception about the settlement communications rule is thinking that labeling something a Rule 408 communication will make it inadmissible. That's not necessarily the case, but all the time you will see lawyers, when they send a letter or an email about settlement, they will put at the top, "Confidential Settlement Communication Rule 408." Probably in bold and maybe with some asterisks to really emphasize it. That's not necessarily a bad idea, because if there's a dispute about that communication later, that label will at least show that one party intended the communication to fall under that rule and intended the communication as an offer or discussion about a compromise. But just because you label something a Rule 408 communication does not necessarily make it inadmissible or privileged or confidential. The number 4 misconception about Rule 408 is thinking that the rule bars admission of evidence of a statement in a settlement negotiation for any purpose. That's not the case. The rule applies when the purpose of offering the statement is to prove or disprove the validity or amount of a disputed claim. The rule itself expressly says that evidence of a statement in a settlement negotiation can be offered for some other purpose, for example, showing the bias or prejudice of a witness. If you've ever had to research how courts have applied Rule 408, as I have, you will see that there are many cases where the courts say that a statement in the course of a settlement negotiation was admissible because it was offered for some other purpose. The number 3 misconception about Rule 408 is thinking that the rule can be used to cover up evidence of commission of a crime. That is not the case. This is kind of a corollary to misconception number 4. Remember, I said that the rule does not prevent somebody from offering evidence of a statement for some other purpose. If that other purpose is to show that some crime was committed in the course of the settlement communication itself, then Rule 408 probably is not going to apply. Even the attorney-client privilege, which is a much more powerful privilege than the settlement communications rule, has an exception for a communication in furtherance of a crime. So if a communication in furtherance of a crime is not going to be protected by attorney-client privilege, it's a pretty safe bet that it's not going to be protected by the settlement communications rule either. The number 2 misconception about the settlement communications rule is thinking that it is a rule of confidentiality. It is not. It is a rule of admissibility. It governs whether a statement will be admissible in a lawsuit in court. It doesn't have anything to do with whether a party to the settlement communication can disclose that communication to any third party or to the general public. Now, in some cases, the parties to a settlement negotiation may have an agreement to keep those communications confidential. But in that case, the question would be whether there was a breach of that agreement. That has nothing to do with Rule 408. And finally, the number 1 misconception about Rule 408 is thinking that it is a rule of privilege rather than a rule of admissibility. What do I mean by that? Let's compare it to the attorney-client privilege rule. Generally, if I have a communication with my lawyer and it's confidential and it's in furtherance of the lawyer providing me legal advice, that's privileged, which means in a lawsuit, the opposing party cannot demand disclosure of that communication. That's not how the settlement communications rule works. It's not a privilege, it's a rule of admissibility. It goes to whether the statement will be admissible in the trial in court. That has nothing to do with whether the communication can be discovered or whether it has to be disclosed in, for example, pretrial discovery in a civil case. So don't think that just because a settlement communication may be inadmissible, that means that you would never have to disclose it. So those are my top 5 misconceptions about the settlement communications rule. If you agree or disagree, or maybe you've got some other misconception you want to highlight, leave a comment. And if you liked the video, please hit the like button. Even better, please share this video with someone you know. And hey, thanks for watching.